The Reconciliation Commission, yeah.
You're live. That sounds fun.
Yeah.
Senator, you're live.
Thank you.
One second.
This is Senate Transportation, and we're resuming our testimony on S4, and we have Ledge Council here, and Tucker's here to school Damon.
Happens a lot.
It is a rare occurrence, and for the record, Tucker Anderson, Legislative Counsel,
Damian Leonard, Legislative Council.
and you all had a very exciting morning. You're starting with the ice cream sundae on this issue, and it might make sense to kind of walk backwards to the broccoli and potatoes, meat maybe.
I think what our attempt was to get the issue at hand that brought this in front of us.
Absolutely. The issues that have been raised are fairly sophisticated. You've had some constitutional concerns raised. There have been issues raised about how the General Assembly perhaps self-regulates on some of these issues. What I'd like to do is start with some of the basic questions that were asked, cover those first, tee up some later legal analysis that Damian and I can give to you to help clarify some of these issues, cover some of the points that were raised one by one, just with some basic overviews of the underlying law. And if that doesn't resolve many or all of the issues that have been raised before you this morning, we can come back with more in-depth legal analysis. I think the easiest place to start is the question of what is a trail? And perhaps it is a disservice that in one part of this bill, the term legal trail is used, because trail is expressly defined in Title 19. It's defined in Section 301 in Subdivision 8, and it means a public right-of-way. Emphasize that, use it as a foothold for later, because we're going to come back to rights of way. That is not a highway. Interesting. And that Subdivision A previously was a designated town highway having the same width as the designated town highway, or a lesser width if so designated. So that is perhaps what you know as declassification, moving from one class of town highway down to a trail, and either maintaining the presumptive rod width of that right of way or making it smaller. Subdivision B, a new public right of way, laid out as a trail by the legislative body for the purpose of providing access to abutting properties or for recreational use. All right. There's a clause in there about the construction of this definition, but that is the gist right there. Those are the trails that we are talking about.
Yeah, just a quick question. So the second part, is that an and or an or does it modify all trails or some trails?
It is or. It's an or between A and B. It is
Okay.
either those that were a previously existing town highway that have been designated as a trail, or those that have been specifically classified as a trail.
Okay.
A new trail.
Have you done any research about the Supreme Court case that brought this on?
That brought the current issue on.
No, that brought this on. There was a Supreme Court case, and there was legal title issues, particularly I think it was around title insurance, and they used that brought that this law on, and it was probably from about 2004.
Next step in understanding some of the trail issues that are being discussed here is perhaps separating the trails from what the legislature tackled and what was colloquially known as ghost roads, or as Paul Gillies famously classified them, the ancient roads.
Yes, and Paul testified in front of the House Transportation Committee at the time, and was very instrumental.
So I don't want to dive too deeply into that, because we can actually keep that discussion quite separate from the legal trails at hand. And what that was at 178, something like that, from the session that it was passed. It had a 5-year period over which municipalities were mapping the unclassified, or let's call them the unknown highways that existed within their municipal bounds, and then either allowing the right-of-way easement to extinguish and pass to the landowners, or designating them as town highways. One of the things that you will note if you go back to the legislative process around that and Act 178 itself is that there was the General Assembly expressly excluded trails from that conversation, specifically around the presumptive extinguishment of trails. So, separate. Happy to dive deeper into the ancient road stuff
I
too.
think we need to move along and
Yes.
get
I pointed out that these are rights of way. That's something that we should likely revisit in the future so that you can understand what a right of way is and what rights the owner, i.e. the municipality of the right of way has, either in the instance that what this highway, right of way, or now trail was, either the municipality owned the underlying land in fee simple and has a right of way passing over it, or more likely case when we're dealing with these trails, that the ownership interest is an easement which passes over land that is privately owned in fee simple by the abutting landowners. The right of way carries with it the right of transit over the surface of the right of way. And at common law, and in almost every single jurisdiction that has interpreted this, there is an accompanying right to repair and maintain the right of way for the purpose that the easement was recorded for. You might, in some of these instances, have different rights associated in the easement, i.e. you might have an easement that was recorded specifically for the purpose of pedestrian traffic. And we do have instances that we can show you where that was the purpose for which the right of way was established. You may have instances where the easement was for purposes of transit broadly. And then the legal question, which is at least unresolved for me at this point, because I only started researching yesterday evening, is whether by classifying this as a trail, you have somehow taken away or given away a right from the easement if this was originally a right of way for transit broadly. For example, a class 4 road that has now been converted into a trail.
and you have a piece of, you've created a landlocked piece of land behind it.
I'm not certain about that.
Yeah, just keep going.
Yeah, so let's try to stay away from things like easements by necessity and so forth,
Yep.
where you have
Prescriptive easements and
right. So, like one of the issues that comes up when you're conveying land is if you've conveyed land so that you have a landlocked parcel that doesn't have access to a public right of way.
Or
Is
it
there-
was a public, or it was a class 4 road, it gets thrown out.
Right. So there's a variety of issues that have come up in Vermont in the last 20 or so years on this, where there are unidentified corridors and roads where historically there may have been a road. It wasn't on highway maps. So you're looking for, and there's no immediate evidence that the road was there. So you start looking back at old maps, old deeds, evidence, which could include things like fence lines that are now buried in trees running along the road and things like that. This is something that is, I think, separate from what we're talking about here. So this here, we're talking about a trail that's designated on town highway maps, and it was designated, the legal trails are trails under 19 VSA Chapter 3 that were designated on highway maps as public rights of way that had existed prior to the 2006 Act that required mapping of these things, because at that time, a significant number of class 4 roads and legal trails were not on town highway maps. And the large reason for that was that municipalities did not receive state aid for the maintenance of those rights of way. And so they saw no reason to keep them on map. As you can imagine, this created issues for landowners who didn't know that there was a right of way across their land. And I want to be really careful to stay away from the case, because we're not an adjudicatory body and we don't provide opinions on the case as to what the uses were and so forth. But it's important context to understand that these trails, which are called legal trails in some places, but the definition only says trails, are public rights of way that were designated through that process, or identified through that process and then put onto the highway maps. So, and there are a number of them throughout the state in a number of municipalities, and they vary in characteristics. But the important characteristic is that they share is that they are a mapped public right of way. So.
And this hopefully is going to be the last helpful piece about the trails, but there were several instances this morning where the timing of the existence of trails was brought up. Trails were initially introduced into Vermont statute in 1921, Act 121. So knowingly or unknowingly, the case was confetti for the centennial anniversary of the existence of statutory trails in Vermont. A few more points to move through, unless Damien, you have anything else to add on rights of way or
Not
trails and
at
statute?
the present time, but as Tucker said, we're happy to.
Another thing to note just about municipal interaction with rights of way broadly, is that there is a municipal officer that has express authority in statute to perform specific type of maintenance on any public right of way in statute, and that's in Title 24 in the shade tree chapter. Tree wardens have the authority to remove trees that pose a public hazard on any right of way. It uses the term public way, which is defined for purposes of that chapter as any public right of way. I want to talk a little bit about the discussion you had around the policy of not passing bills, working through legislation that relate to pending or ongoing litigation or matters before a court of competent jurisdiction. The term that was used was policy. No, not a policy. And certainly nothing, as I stated when you asked me, Senator Harrison, on the record, definitely nothing that would constrain the General Assembly, nothing in the Constitution. Your plenary authority, within this context still exists. It is perhaps discretionary acts of chairs or members to not meddle or interact with ongoing litigation, but there's nothing that would prohibit the General Assembly from acting. And I would flag that how would many of your committees even operate if you couldn't work on legislation that relates to ongoing litigation? How would the judiciary committees exist, for example? How would you work on Act 250? So that's a great point. I would say that, you do have two statutes in Title I that affect how an act of the General Assembly is construed for purposes of pending or ongoing matters before court. Sometimes you notwithstand them so that an act of the General Assembly expressly applies to an ongoing matter, but we do have two sections in Title I that clarify how an act of the General Assembly would be construed for purposes of ongoing litigation.
Right. 1 BSA 213 specifically says no act of the General Assembly shall affect a suit begun or pending at the time of its passage, except acts regulating practice in court relating to the competency of witnesses, or relating to amendments of process or pleadings. It is worth noting, we do notwithstand that. And it becomes a really a question for the committee's jurisdiction as to whether they're going to take action or wait to see what the court's judgment is. So when you have an ambiguous statute, you may wait to see, well, how does the court interpret the statute? Because if they interpret it one way, maybe the action we were considering isn't required. If they interpret it another way, maybe we want to clarify to reach what we think the intent was. Because sometimes the court and the General Assembly, you don't agree about your intent. The other thing to note is that there are times where, because of public policy issues, you affirmatively choose to act to clarify the statute or to provide certain rights that may not have existed. An example of this, and it's not an apples to apples example with the case that the witness earlier was talking about. But if you'll remember, several years ago, the statute of limitations on child sex abuse was taken away during the middle of the sex abuse lawsuits that were going on related to the orphanage in Burlington. And so that's an extreme example, but that was an instance where the legislature, knowing full well that there was ongoing litigation, said, we think it's important to make a change to the law here. There are other instances that I can think of in my time, particularly in my previous role here doing employment and labor law, where we would look at a case pending before the U.S. Supreme Court, for example, or the Second Circuit, and say, let's see what they say. Let's get some clarity on this issue and then move forward with that clarity. And a lot of times it just depends on the issue that's before you. So
I would just say to you that the line from 2006 came out of a Supreme Court decision that the legislature felt it needed to react after. So,
right.
But I think you're all over the map.
Right. And so that's, I think, the important thing here. And I think, the witness earlier clarified the statement from their written testimony to say that, that they didn't see it as binding. And I hope I'm not misrepresenting the testimony, but rather that they were noting that there were prior instances where the legislature had chosen to wait. And at the end of the day, I would say it is up to you. It's not for us to say whether you should wait or not. But it is something just to keep in mind. There's nothing that prevents you from acting. You may choose not to act because you want to see what happens or because you think the issue needs more time. There are a variety of reasons why you may choose whether or not to act. So.
All right, the last issue that I'm going to tee up, and this is really the dessert. This is the most delicious for attorneys to kind of chew on here, is some of the constitutional parameters around takings. Here. And what I'm going to do is I'm going to tee up a few necessary steps to get to some of the analysis that you have already received, and then offer to provide further analysis on this subject where the memos received may be silent on some of these issues. The first you have to approach is, what is the municipal government interest in the right of way? It is indispensable to evaluating the tension between property interests that are in future. So critical. Second, what in S4 regulatory alteration of the scope of authority. Inherent in that is understanding whether there already is municipal authority to repair or maintain the right of way. If there is some sort of regulatory alteration by allowing the maintenance, then you can start to get into some of the discussion around the parameters of a potential taking. And finally, understanding whether Vermont statute already accounts for a potential taking in this context. And one thing that I would flag is that there are many cases that examine rights of way in terms of takings. And one of the foundational points of analysis by the courts is whether the physical bounds of the right of way are being changed by the action. In this case, one of the things that you will want to hear about and analyze is whether this is a significant alteration after you have done all these other steps. If it is a minor alteration or not an alteration at all, you already have a statutory structure in place for landowners to appeal a potential takings caused by that minor alteration. And another thing to point out is that, as I discussed earlier, you may have different easements that are impacted here with different rights associated to them. And one of the things that is relied upon in the kind of this act is unconstitutional arguments is that this is universally affecting a taking.
Sure. Good. I have a question.
Thank you, Mr. Chair. So when you say significant alteration versus a minor alteration,
Those are the terms that are used in Vermont statute.
what would, we had the term like occupation used earlier and the idea of like chainsaws or a backhoe. Is there a clear point between when that would become from minor to a significant alteration? Because for me, when I look at what the change would be, it's continuing the practice of like moving brush or like cutting down a log. And that feels minor to me, but do we have a definition of where that line falls?
That's a level of specificity that I would feel more comfortable coming back to the committee to discuss if you want to do a deep dive on the takings issues.
I'll think about it.
On easements, when you use that term, you mean both like a legal easement, like a written easement, and just using the term like right of way is an easement because you have the right to travel over it. That's an easement, but it's not written down. Right? Are you defining it? You're using easement in the broader sense.
So,
Or both.
yeah,
Okay.
it's worth noting that when we say easement, it can include a right of way for travel. Easements also include other things such as a right to, run utility or telecommunication lines over land or under the ground on the land. So there are a variety of easements for water pipes.
Right. But a right of way is an easement.
Yes, it can be a form of easement.
What do you
so,
mean? Like it just
like,
is.
yes. So right of way, if I were to grant an easement for a right to cross my property, that would be a private easement. So public rights of way are a little bit different. So
They're not easements, or they are.
a public right of way is an encumbrance on the property. I'm not sure if I'd characterize it as an easement or not, but I tend to think of them as something you grant in a deed to a neighboring landowner. Tucker, you wanna?
I would term it as an easement. Happy to be corrected, but this is the term that is used in most of the case law that I have read.
And there's some easements that are very specific, like you could do this thing.
Both under Vermont law and common law, but one thing that I definitely want to be careful about with what Damien just brought up is that each one of the easements that he was naming are separately held. They're not all part of one thing. And what we're talking about here is just the right of way. And the memo you received talked about other forms of easements that have been evaluated, including railway easements, which are held for a specific purpose. And when that purpose is changed, you have a taking. So that's part of what I was talking about with some of potentially the change here, or maybe no change at all. Is there a change in the purpose of the easement or in the authority of the easement holder, the interest holder here, which is the municipal corporation, to maintain that easement?
So if that's my kind of questions on this right of way, just the easement. And if the easement was never specified, like a railroad easement, or like you specifically said, you can travel on this, across the property for this purpose. What constrains that easement or that right of way? Does it mean, is it limited, or have the courts decided how to define what that right of way entails?
I would love to give you a whole bunch of treatises that are available on easements under Vermont law and how they're, at least for these purposes, potentially various.
Deeded right of way and easement.
Gated right of way.
Deeded. Yeah.
Yes.
So, yeah, that would be, so I've,
We're not really dealing with that.
but no, we're dealing, and that's one of the important things here is the, your witness earlier described how, in law and particularly in law school property classes, we talked about the bundle of property rights. And so and then we often break that down to the sticks in the bundle. So it becomes easier to start picturing it metaphorically. So, a deeded right of way, say for a driveway, that is an easement that you have purchased from your neighbor or acquired from your neighbor. Sometimes you can acquire it by adverse possession. We're not going to go there today.
Yeah.
But it's a right that you've gotten to use it for driving. If you want to modify the use of that easement, you don't necessarily hold that right because your easement is for travel. So one of the things that we may want to look at here is whether there's clarity as to what the public right of way is for, because that's really the public holds, the town holds a right of way on these trails. The question is, what are the acceptable uses? And I think I'm trying to tread carefully here because I imagine that some of this is at the heart of the ongoing litigation, and I don't want to inadvertently step into the pitfall of Ledge counsel spoke off the cuff and gave an opinion about ongoing litigation. So I'm avoiding that.
You're poking a lot of history for some of us.
Right. And I think
I would just say your issue of what is maintenance and that the Supreme Court case that is coming back into my memory was a house where there was a class 4 roadway. In the middle of the class 4 roadway, grew up a maple tree. The maple tree was about 90 years old and was a significant tree. The landowner bought the land, didn't realize it was a class 4 roadway, and it precipitated. They came in and said they were going to cut the tree. The tree was a major part of what was at the house's lawn. And it ended up all the way in the Supreme Court, and the 2006 law came out of all of that.
right.
So whether that was maintenance cutting the 90-year-old tree or what really became a question.
Yeah. And I think what might be good here, to get back to the vegetables, is to come back with more of a legislative history on the 2006 law, the 1921 law, the 1986 amendments that were mentioned earlier. Give you a bit more sense of what was granted and not under these various laws. Look at the court cases, tell you what the courts have looked at, what they haven't looked at. I imagine that there is ongoing questions and blank spots here. This is Vermont. We have very little case law, and we tend to have very short statutes, thankfully. So there are always these areas of these gray areas. And we're a small state, so we don't have a lot of, for better or worse, we don't have a lot of cases that make their way up to the Supreme Court to get us binding precedent. I'm sure other witnesses will have opinions too, but we're happy to put together a history for you and some background on these legal issues that you can use as a guide as you hear testimony from others. And then to go forward from there. And then I would say one of the difficulties being here this morning is having just seen some of the testimony last night, it's hard to respond to it.
We're going to
So,
move ahead. We need to go through the bill too.
Okay.
So,
Can I just,
no, at this point, we're here to listen to our counsel. And, if there's further information, anybody's welcome to send, request testimony again, or send us something in writing. But we're here to learn, and so I need to. Go ahead.
So when you're doing this, is the question that I have is if the town has an easement for transportation because it once was a highway. It is no longer a highway. And it was never specifically said what the easement was for, because it was just known easement. It's a known right of way that people traveled on horse or maybe early vehicles. How do we define what that use is? And or is that the question that we have to do in the law and say, like, so if it was used for only horses and then give up, then the became a trail when horses were around. So is horses kind of like the maximum amount?
I think it's worth keeping in mind that the bill in front of you doesn't specifically define the acceptable uses of these rights of way. The question in front of you, and you could take it further and say that these legal trails can only be used for, certain things. That becomes a bigger question than the bill in front of you, which is talking about the municipality's rights to enter on and maintain. And
I think I disagree on that. If the municipality has the right to maintain it to what level of transportation? So if it once was a road, is now a trail, and they maintained it to become a road.
We can absolutely come back to you
That's
with a
my
response on that.
I think we need to go back. I think we really need to go through the bill
Okay.
and ground ourselves in the bill and
pages,
then
though.
move out from there. And because we do have to be, I have a hard stop. And I'd like to give people a few minutes before we go to the floor. So quarter after, and we've got 40 minutes and we may have questions in the bill. And it may lead directly into the question that Andy's
Where's
asked.
that?
We will jump right into it then. Section 1 amends 19 VSA Chapter 3 related to town highways. The first set of amendments is in section 301. I will note that the first two instances of amendment UUC amend the definition for legislative body and selectmen to cross-reference sections in Title 24 and to change those terms from selectmen to select boards and legislative body as appropriate. In subdivision 8 of this section, and we're on page 2, there is an amendment within the definition of trail. States that trail means a public right of way that is not a highway, and that in the new subdivision A, municipalities have the authority to exclusively or cooperatively maintain it.
I just have a quick
Go
question.
ahead.
So this feels like the most, this is what's on,
Who's looking?
page 4. This is like the most critical piece of change. Is kind of what I picked up on. At least that's what I think. Can you just tell me exclusively or cooperatively? Exclusively, I get it. It means they can do it on their own. They don't have agreement with the landowner, is my assumption. And then cooperatively means if the landowner agrees. Is that the right way to interpret that?
Or potentially a third party
Or, oh, okay, yeah, or they could contract that. Okay, thank you.
or other municipalities, which
Okay.
there's cooperative highway maintenance mentioned in Title 19.
Thank you. Can I ask a question?
Go ahead.
Why wouldn't cooperatively just be assumed? Why is it necessary? Why wouldn't you just say exclusively? Because then you could always cooperate, I would hope.
This strikes at the heart of some of the legal arguments that you have heard this morning. Whether or not statute related to this issue or to municipal government and municipal power in general needs to call out expressly all of the authority that can be exercised by a municipal corporation.
But
Remember, part of the issue here is that the statute is silent on whether or not a municipal corporation has the authority to maintain, period. So
isn't this giving them isn't the
Yes.
authority exclusively at a higher level? Isn't that more authority than cooperatively? Why would you say or?
if exclusively was called out alone, it would eliminate the possibility of the municipal corporation with others.
Really?
Yes, because you have a narrowly defined term, exclusive, that is
Okay.
modifying the authority here.
So why would you just not say have the authority to?
That is a fantastic question. And as was pointed out in earlier testimony, this bill was brought up in a prior biennium, and perhaps there was a reason that I can find for you for why exclusively or cooperatively was included in the language of this particular subdivision.
Okay, so more to come.
Always.
Okay.
All right.
Perfect. Moving into section 302. Here are some conforming amendments from the change of the definition from selectmen to legislative body. We're moving to subdivision 5. The amendments here state that trails shall not be considered highways. Full stop. A municipality shall have the authority to maintain trails, but shall not be responsible for any maintenance, including culverts and bridges. And another foothold that I neglected to bring up, even though it was in my notes for your later consideration, is that there is separation between duties and authority. They are separate things. And what we're dealing with here is the duty to maintain. In the 1921 Act, and for most of the history of the trail statutes, what this was targeting really was liability. And that is the term that was used throughout most of the life of this statute, was that there was no liability to maintain. And if you remember the initial walkthrough that I did with all of you, I pointed out that the duty here is very closely tied to analysis for potentially tort litigation related to this. Duty is a necessary criteria that a potential litigant has to show.
Well, I had liability written previously underlined right there. You did explain.
If you just, yeah, I just say to you, I don't remember everything when you came 2 months ago. But that's my short-term memory, but it is jogging my memory to 2006. So it may speak about my age.
I am trying to avoid flashbacks to 2006. My apologies.
But fine. So they're very vivid. 2 months ago is not. So.
I was a junior in high school in 2006, so I also don't have very good memories that I'm trying to avoid.
Can I just ask one other question before we get to the next part? Just to be clear, legislative body is not a planning commission.
No, go ahead.
It's just the select board. It's, okay,
Yes, select board, city council, trustees of the village.
okay. Thank you.
We're going to move on to page 4 here, amendments in the section 304 governing the duties of the select board. There is first some removal of gendered language here in subdivision 16, changing him or her to the road commissioner, which is the office that is discussed in subdivision 16. Subdivision 24, there is added authority here. Stating that the select board has the authority to maintain trails, and then a clarifying clause, but shall not be required to maintain trails, and shall not owe a duty of care. This is where liability came up last time, to persons using a trail that is maintained by the town. So this is carving away the express duty, also carving away the liability, which again is what the statute was doing for many years, but granting express authority for maintenance. granting authority, making sure that duty and liability are separate.
Just, this is my opinion too. So using a trail that is maintained by the town, why don't you just say using a trail? Because if it's not maintained by the town, or if it is maintained by the town, then it's maintained by the town. I know that. You know what I mean? I'm not asking the question though.
I will,
Well, like, it should be not, the town should not be required to maintain trails and shall not owe a duty of care to persons using a trail, period.
it's clarifying that for the purposes of the trails that are maintained under this authority, that there would not be a duty of care owed to those who are using the trails that are being maintained by the town.
What if they're using a trail that's not being maintained by the town?
Fantastic question that I can take a look at some of the existing trail statutes to see if there is already a relief of liability
Right.
for municipalities for those that they are not maintaining, either in statute or under case law evaluating courts in this area.
Okay.
So even more.
So
Yeah.
I think we'll want both the liability of the municipality and the liability of the landowner. Because in some cases, I can think of where there was a trail, there's people put in driveways and in the use of that, if someone falls,
Right.
who's liable?
So I do want to note on that last question, under 19 VSA 310C, it does currently say a town shall not be liable for construction, maintenance, repair, or safety of trails. So that already sort of says that they're not liable for if there's an unsafe condition that develops on a trail. So that's already provided in statute. So, and I didn't work on S4 or its predecessor. So we can look back at the reason for that, but I imagine some of it is a question of if the maintenance results or doesn't address a condition that's unsafe. There's a question of it. I'm sorry.
That's what I figured. That's my understanding. No, I understand.
Conversely, if they do maintain.
Yes,
And they do something and it results in some injury,
yeah,
do they,
So under the bill here, it would take away a duty of care to the persons using the trail that is maintained by the town. So, I mean, if you do move forward with this, and I understand that that's not a settled question yet. The question is, do you keep this language as it is? Do you explore that duty of care, et cetera? And these are policy questions for you. The bill as proposed takes away the duty of care or provides that they do not owe a duty of care. So it is, as Tucker mentioned, a protection from liability. But these are policy questions for you. And if the bill moves forward or gets rolled into something else, the language is open to amendment.
so just so I'm clear, so it's a trail, it's being used by bikers. The town goes in maintenance, town puts in a water bar, somebody comes and hits that water bar, he goes off into the woods. The town under this would have no maintenance,
No duty of care.
with the landowner though? Like if that happened,
but the landowner didn't do the,
well, yeah, I guess that's my question is if the water bar got put in or it was there, does the landowner have liability if someone flies off into the woods?
This gets more complicated. And again, I would rather
Okay,
take the time to research this thoroughly.
yeah,
And, there may be, I imagine that becomes a more fact specific inquiry. But this is when you start getting into landowner liability for folks who are using their land, there's a number of questions that start to arise that affect that liability.
I'm now having flashbacks to 1L year torts class and landowners that have trees that impact sidewalks and other similar.
we've also passed landowner liability laws in the last 25 years.
Hmm.
So
Right. And so
I
there's,
just,
yeah, there's a number of questions here that I think arise out of that, but these are all involved questions here. And, I think it's going to be to some extent fact specific and to some extent, there are a variety of issues that may be worth considering.
Are we ready for section 2 of the bill? It amends 24 VSA section 2291, which our GovOps member is probably intimately familiar with at this point. It contains the police powers, the enumerated list of police powers of municipalities, and it has a new subdivision 31, which would authorize municipalities to regulate by means of an ordinance. So call that specifically the use of legal trails under 19 VSA Chapter 3, including the regulation of the types of vehicles that may be used on legal trails. And if you do want any in-depth background on ordinances or this area of the law, happy to dive into that at some point. It's where I'm most comfortable.
And I do need to apologize here because I misspoke earlier. I think I responded to your question that this was dealing with the maintenance right and not potential regulation of the types of use. And it is dealing with regulation of the types of use. So I need to just correct my testimony from earlier and apologize for that mistake.
So yes, obviously we spent some time on this in the other room, but so this could be types of vehicles, could include ATVs, could include snowmobiles. Is that correct?
Vehicle defined?
Yeah, what,
I couldn't find it.
because I learned that motor vehicle includes motorcycle on the floor earlier in this session. But does vehicles include like ATVs and like four-wheelers and stuff?
Yeah.
So they could say, so under this, the town could say, we don't think that you should have ATVs on this legal trail. They could limit that. Or
Right, by means of an order.
by means of an order, they could pass an ordinance to do that. And I thought they did have the ability to do that now.
There is the authority to regulate the use of ATVs, but
That's
I don't
on
remember what might be
highways.
town highways. Yeah.
Yeah.
So they could, okay, so this is another angle. I know in South Royalton in particular, this has come up a few times with folks who live next to trails that are now being used by ATVs. They say, I would prefer not to have those ATVs be going by. But does that also include snowmobiles?
I'm so glad the transportation attorney is here.
Yes.
So, yeah, a vehicle, it's not specifically defined for that chapter, so we use its common meaning. So vehicle is essentially anything used for transporting people or goods.
About a
Over. What's
a pogo stick.
Not good on a trail.
Not good on, well, then you
On a
might
trail.
pave the trail.
But yeah, I mean, these are some of the policy questions that are raised by this bill. One is, do you want to, it one grants that right to maintain. And then two, it grants the right to determine the types of uses. And I imagine, again, that could raise other issues, depending on the trails and depending on the municipality. So as we all know from their,
I can
different-
clearly see in this, take out the ATVs, and which there are clear dividing lines. But I can see a mountain bike trail. And as we get more and more sophisticated e-bikes
Mhm.
that go faster on a trail that is not made for that, and you may have a lot of more ticklish situations.
right, there's a number of vehicles that, as we know from our work in here, raise questions and concerns from a variety of different constituent groups that you all hear from. So that is that's a policy issue that is one that you should not ignore. I obviously can't tell you how to come out on that, but that's a significant piece of this bill if you move forward with it. And just one that's worth looking into more deeply and hearing from witnesses on and getting further testimony on. And it's so, that I think your breakdown on this bill is really those two big pieces. And obviously there's questions, a number of related questions going on around this, including those that have been raised by the ongoing litigation that was discussed earlier. So, I think that's where you're at. You have a lot of thinking to do. So,
No, there's a lot of
Yeah.
thinking to do, and there's a lot of talking to do, because regulation of the types of vehicles, I mean, we could want to say the time of day that they would be going, we might want to say, the quantity of the vehicles, we might want to say the seasonality of the vehicles, we might want to put constraints on certain places where we might want the property owner to have a say. I mean, this could get very complicated. And my understanding is the state has to give municipalities specific authority, right? I mean, if we don't put something in here, they won't have that authority.
The judicial gloss of Dillon's rule in this context requires that if there's any doubt or ambiguity as to the express grant of authority to the municipal corporation, then the courts will construe whatever the delegating statute is against the exercise of that power by the municipality. So it must be expressly granted.
Okay, so use of the legal trails, we say including the regulations of the types of vehicles, but that would be one instance. But maybe we need to look at the other instances.
Except that including means including, but not limited to.
Right, well, I'm sorry, yeah, that's what I would expect. So, but then on the other hand, we're saying you can't do it unless we tell you actually can do it.
Except that here there is an express delegation to the municipalities to regulate the use of the legal trails.
So that would include things like time of day, number of vehicles, allowing the property owner to have a say, weather, yes. Or
Potentially,
maybe, okay,
and
maybe.
I would have to do some research on how the
Okay.
term use has been
Okay,
analyzed in this context.
okay,
Right.
so it's gonna be
I
complicated.
can give you examples that in other contexts, particularly within section 2291, things like the ability to license within a delegated authority must be expressly called out because it will not be inferred as part of another delegated authority. So more to come again.
Great.
Yeah, and if you can, within the transportation bill that we walked through yesterday, you remember the rail trail sections where we were talking about things that are specifically prohibited?
Yes.
That, so the state is one of the trail sponsor options. The other is municipalities. Again, this is basically setting out, they can regulate consistent with these express prohibitions on uses for the rail trail. So things like, prohibiting the discharge, picnics except in designated locations.
Yeah,
Which they could designate the entire rail trail. Or the discharge of firearms.
Yeah.
Except as permitted by law, not expressly.
Molesting wild.
Yes, molesting wildlife except for fishing. Right. So there we were setting out, again, really pretty prescriptive guidelines. This here says regulating uses, including types of vehicles. So this is a much broader grant.
But
Of
an
authority.
important note that within the context of delegations of legislative authority to municipalities, the Supreme Court of Vermont has said that these sort of powers will be harmonized with other conflicting general law governing the same subjects. So something else that I'll look into along with Damien to provide guidance on where there might already be constraints on what can be regulated. Subject.
Yeah, without a term.
okay.
So just one last thing that I want to say is, like, if we're gonna move forward with this, I would want to know that when we say they have the authority to maintain trail, if there's any limit on that. And I assume that would be maybe based on the past use of rail or the highway, but maybe not, because it's not.
Well, did you say earlier it was within the physical boundaries of?
Right.
It was minor versus major maintenance? Or
Yeah, that was-
major-
Well, that was within the context of analyzing potential takings. Again, jumping to the dessert.
Yeah, and when you said physical bounds, I don't think you meant the, like the lines. I think you
Which-
meant all sorts of things.
That's the metaphysical bound.
I was talking,
Did you mean just the
I was talking about the
like-
actual
like the
bounds of
line?
the easement, like
the
where
line?
the easement is
Okay.
defined physically.
Okay.
Because once you start
That's easier.
physically invading outside of those lines, that's where the takings analysis maybe gets a little more clear.
Okay.
Yeah, that's really important, actually. It's the bounds of the easement.
Oh, no, I understand, but I
Yeah.
thought, but you have, you know, what you can do in this area, but then you can also, there's different things that you can do to the property that are, some are more impactful and
Mhm.
invasive than others.
Well, that's
Like
kind of-
digging it up rather than,
Right, I
Walking
mean, one
along.
of the things
What
they
is
look
nature?
at and
well,
is going to be the nature and scope of the invasion of the property. If there's an invasion of the property, you're going to look at the nature and scope when you're doing the takings analysis. But, you know, you've got to get to the point where there's an invasion, and those, depending on the analysis, and I'm saying this conscious that I have someone who studies takings in the room.
but they
So
can
I feel
all
like
be
I'm back in law
watching
school again.
anyway.
But the, you know, the analysis, there's a number of other things, and then you do look at the scope of the takings there. So there, you can have takings that are from, you know, very minor takings, but there's still a taking.
Yeah.
And there's still a need for compensation or other action, to takings that take away the entire use of a
Yes.
piece of property. And so there's a broad scope there that needs to be looked at. And then, so there, I think the bottom line is, I certainly am not prepared to go into a full discussion of takings. I need to remind myself of where the boundaries lie on the different processes. I know there's another witness in the room who would be happy to weigh in on that, but we will provide you with
Well, thank
our information. I'm sure other witnesses will as well.
It's been
Since we
helpful.
do have a couple of minutes, if you'd like to make it, it has to be less than 5 minutes comment.
Just for the benefit of the council, this is just really help you out. The takings issue has not been debated in the context of an ongoing litigation.
Okay.
But the question of the scope of state authority, the history of the 1986 legislation, all of that has been exhaustively briefed by the parties. And I just, you know, to expedite your research, I encourage you to get the full set of briefs that have been filed in the Superior Court, because you're addressing or talking about a whole lot of issues that the parties have thoroughly written about. That's
Good to know.
and not specific to Tunbridge or this trail, but to this legislative scheme. So I think you'll just find it helpful.
Thank you.
At this point, because we have a few minutes before we go to the floor, I'm going to